Please, Your Lordship.
Yes.
I'm grateful for the opportunity over lunch to consider the way forward in the remaining afternoon of today and looking beyond that. So I do intend to proceed at a pace through the grounds of appeal. I do appreciate some might say I was rather long-winded this morning, but
let's not go back. Let's go forwards. Okay.
In response to my Lord Justice Lewis's questions about arrangements for marriages in 2020,
yes,
my learned junior Miss Smeaton has has located this short report, effectively, the statistical bulletin from the ONS, dated 11th of March 2023. So we hope this is of assistance to the court on that. I'll just give you a moment.
It shows the impact of COVID on the number of marriages.
Yes, indeed, and
yes.
The graph on page 4
yes.
that says it all.
You've already taken us to the evidence. And
yes,
the accepted position in this case.
Yes.
Thank you. Yes.
And we say that accepted position was right in light of that, this additional document. So turning to the appellant's grounds of appeal, which I will just go through relatively succinctly. The replacement grounds of appeal are at pages 95 to 96 of the core bundle.
Yes.
Paragraph 11 on page 96 should, of course, say Appendix EU.
Yes.
Not FM.
Yes.
That aside,
yes.
The appellant relies on those. And you have the appellant's detailed skeleton argument also within the core bundle. That's at pages 103 to 128.
Yes. Thank you.
So, in light of the points made this morning, and turning to paragraph 22, that's grounds 1 with grounds 5 and 6 combined.
Yes.
We say the upper tribunal erred in law on the correct approach to interpretation of the withdrawal agreement, and we've referred already to Article 32 of the Vienna Convention, and just to be clear, we are not asking the court to rewrite the withdrawal agreement. What we are submitting is that, in light of the interpretive provision of Article 32, that the Secretary of State and/or tribunal judges, decision makers in these cases can and should take a purposive approach to whether or not an individual falls within the scope of Article 10 as a spouse or durable partner in light of the COVID-19 pandemic. That assessment can be made with regard to an application for facilitation or an appeal against a refusal of facilitation, and that the Article 32 considerations would inform an appeal decision as well, a judge looking at a case such as the appellant. And we say that's particularly so in light of Article 18(1)(r), which requires a decision in accordance with the law, looking at the facts and circumstances, and a decision that's proportionate. The Commission guidance on Article 18(1)(r) says that means looking at the law and all the facts and circumstances leading to the decision, we say that covers the appellant's case and the others like it. And that approach is supported not just by Article 32 of the Vienna Convention. It's supported by the principles which we say form the backdrop of the withdrawal agreement, including under the EU treaty, including the principle in Singh and the other authorities that have been cited at, from paragraph 26 onwards of the appellant's skeleton argument, and 28, that requires a purposive, teleological, proactive, flexible and inclusive approach to interpretation that leans against interpretations which result in black holes, which fills gaps which may otherwise exist. I'm paraphrasing, but that's the essential point. And we say that's further supported by the fact that in cases such as METOC, the CJEU, that's referenced at paragraph 30.
Yes.
The CJEU has consistently held that states must not take technical, overly restrictive or disproportionate measures that have the effect of depriving EU citizens of the genuine enjoyment of their rights. And we say that approach informs the withdrawal agreement and decisions taken under it, because, of course, decisions taken under it affect EU citizens, their partners and family members and so forth. And I'd ask you to look at the reference at paragraph 36 to the case of Bai concerning the right to marry being a strong right. I won't repeat those submissions. So turning to ground 2 with 3, this is at paragraph 38.
Yes.
In light of ground 1 with grounds 5 and 6, we say that the tribunal should have concluded that the appellant was or should be treated as a family member. Ground 2 with ground 3, that's 38 onwards. We say for very similar reasons, not least the submissions that have been made regarding facilitation, the appellant should have been treated as falling within Article 10.3, and in fact we say that he clearly does fall within Article 10.3, but if there is doubt about that, we say, in light of the legal materials and authorities that we've already referred to this morning and in the skeleton, he should be treated as such. That's not to rewrite the withdrawal agreement, that is to give proper effect to its intentions in light of very difficult and unforeseen circumstances. We've submitted at paragraph 48 that the enactment of Appendix EU in and of itself can be regarded as facilitation in accordance with national legislation. I've already dealt with that this morning. Paragraph 47, we submit in light of the data referenced at paragraph 47, that the Secretary of State's guidance, the overall message and effect of the Secretary of State's guidance and online information has been to funnel individuals such as the appellant towards the EU settlement scheme without a sufficiently clear warning that the Secretary of State was going to, contrary to our submissions, take the view that this is all about hard cut-offs. And in particular, and I won't go to it because Ms. Smythe will take you through it, but the 11-page document, expanded version of the Secretary of State's guidance that the Secretary of State relies on, it's more extensive than before the upper tribunal, but no matter. We say that if a careful look through that demonstrates there's no clear warning that a failure to specifically apply for a residence card under the EEA Regulations 2016 would be fatal, if not made before the 31st December 2020, the specified date, will be fatal to a subsequent application under Appendix EU as a durable partner. One searches in vain for a sufficiently strong warning, which we say was required, not least by Article 5, good faith, and the obligation to take all appropriate general and specific measures, a very strong duty. There's no red hand warning, and that's resulted in rapidly falling numbers in 2020 applying under the regulations, but exponentially rising numbers under the EU settlement scheme, and that informs, well, that's why we're here today. That brings me to ground 4. The upper tribunal unreasonably found the appellant should have made an application as a durable partner under the regulations. That's dealt with largely by what I've already said in relation to ground 2, combined with ground 3.
Look at your 51. You seem to be saying there they might well have been unlikely to succeed on the substance if they had made such an application. They cannot reasonably be expected to make an application because they've been together for less than 1 year.
Yes, and the respondent's guidance took as its starting point, and I think we've seen that in the rules, that the 2-year measure is what's applied. Yes, well, indeed, but of course, it's a whole different ball game if the population concerned, the sector of the population concerned with Appendix EU and applying and regularising their status in line with the withdrawal agreement, it's a different ball game if it's made clear and apparent to them that if you don't apply for a residence card as a durable partner, even if your relationship is, very short, that could, unless you're able to get married, dealt with that point already, but that failure to get a residence card could be fatal. We don't say all that's right. We've already dealt with that. But what we say is, if the Secretary of State's going to take the approach that facilitation has to be made via the EEA regulations, then Secretary of State has to make it, abundantly clear, big red hand warning, to use the contract term of Lord Denning. And we say that too is a corollary of Article 5, good faith, and it's certainly something that would have avoided this current situation. The upper tribunal, we say, erred in treating the appellant not doing that as being fatal to his appeal, and they said that was a full answer to the proportionality argument. And we say that that is too narrow and clearly wrong. And dealing with ground 7, the upper tribunal erred in law in its approach to proportionality under Article 18(1)(r) of the Withdrawal Agreement. I've already set out the ingredients of what that entails. Much further detail and citation in the skeleton arguments, including the case of Sakarides. The wording of Article 18(1)(r) is virtually word for word the wording of the equivalent provision in the Civil Rights, the Citizens' Rights Directive. I make that point at 59. And we therefore say that the approach in Sakarides, again cited at paragraph 59, paragraphs 49 to 55, requires that an individualised, fact-sensitive proportionality assessment and if I can take your lordships very quickly to the upper tribunal decision. So that's at pages 18 to 53 of the core bundle. And can I ask your lordships to look at paragraphs 62 to 66 on page 46 of the core bundle, and that's the upper tribunal's holding on proportionality. As things stand before this court, the position is that the upper tribunal rejected the Secretary of State's submission that unless the appellant could bring himself within Article 18(1), Article 18(1)(r) simply had no application. They considered that went too far. They then went on, that was at paragraph 62, at 63, they went on to say the nature of the duty to ensure that the decision is not disproportionate must, however, depend on the particular facts and circumstances of the applicant. It may assume, we say that that is wrong. The nature of the duty to ensure the decision is not disproportionate never changes. The duty is to give a proportionate decision that balances up all the relevant personal circumstances as Article 18(1)(r) and the EC Commission's guidance states. And we say that the upper tribunal effectively adopted a fundamentally wrong and impermissibly narrow interpretation of proportionality. There's no warrant for their approach in any of the relevant case law, as I've already submitted. Strikingly, they, at paragraphs 62 to 66, made no mention of the COVID issue at all. They didn't consider the effect on the appellant's wife or his stepchild. They adopted a wholly narrow approach, entirely at odds with the withdrawal agreement. And they considered that the fact that, because in their view, the appellant had not applied for facilitation, that was effectively an answer to any reliance on proportionality. We say that's wrong. We say that with Article 18(1)(r) proportionality, you look at all the circumstances, you have in mind the materials and the authorities that we've already alluded to, and you look at whether the decision to refuse the resident status, which is an entity created by the member state in question, in this case the UK, it's an entity that effectively rises up from the withdrawal agreement subsequent to the state's decision to create such a scheme, and it has to be looked at in that line, and their concern about anomalous results in other member states, we say that is very much overstated and probably even irrelevant, because it will be up to, as we've already said, there's always discretion when decisions are made. That applies in this arena. That applies with regard to constitutive resident schemes, and indeed the declaratory ones. There's always a discretion. What is required, though, by Article 18(1)(r) is a proportionate decision looking at everything. And we say that's the solution to the appellant's case and the many others like him, because proportionality looks at, if you don't strictly qualify, why is that? Not qualifying on a strict analysis is start, not the end of considering proportionality. Other factors, even if strictly speaking one doesn't qualify under a resident scheme, contrary to our other submissions, but even if one strictly doesn't qualify, other factors may push the case across the balance into it being disproportionate to refuse. And we say that this case is absolutely one of those. So detailed further submissions on this are at paragraphs 59 all the way through to 66, and the appellant emphasises we're not looking, as the upper tribunal seem to think, at rewriting the withdrawal agreement. We're looking at making decisions that embody the outcomes that the parties that agreed to the withdrawal agreement had in mind. And they would have had in mind that people that wanted to marry could have got married, and that if the Secretary of State was going to say, well, if you don't make this kind of application, I won't treat it as that kind of application, and that will be tough luck, that should have been made absolutely clear. So that brings me to ground 8. This concerns the interpretation of Appendix EU. It's the submissions that are there. I appreciate, and I believe it was Lord Justice Lewis that pointed out that was a difficult part of the appellant's case. It may be that if the court is with the appellant on any of the preceding submissions, that this doesn't need to be looked at, because it's fundamentally the rights under the withdrawal agreement, substantive and procedural, that are the key matter at play here, key matters at play here. But I have, for the completeness, referred at paragraph 68 to the well-known authorities on this, Mahad, including Mahad. I won't go to that because I'm conscious of the time factor in this case, but those are the appellant submissions culminating at paragraph 70, cross-reference to the definitions example of durable partner in Annex 1 of Appendix EU. And yeah, I won't tarry with that.
Don't worry. Yes.
And then paragraph 9, in my submission, it might be said that this is not necessarily standalone because it should inform decisions under Article 18 anyway. Proportionate decision, looking at the effects on a spouse, a partner, children, other family members. That should all be wrapped up and dealt with in any event, but we make the point at ground 9 in any event. And we've referred to the rights in the Charter. I appreciate the Secretary of State says that doesn't bite, but we do say that, for example, Article 14, the right to good administration, is a subcurrent of this whole case. So you have those submissions at paragraph 71 to 92, and I appreciate I'm going through it at a rate now, but
Don't worry, because we've obviously got your skeleton.
yes. I'll just take a moment.
Yes.
And similar submissions are made under ground 10, paragraph 93 onwards regarding Article 8. And so that's paragraphs 93 to 96. Then ground 11, which overlaps with a lot of the points already made, so I won't repeat. But we say that there are distinct differences in how the Secretary of State deals with other cases. For example, where the sponsor is a British citizen or from Northern Ireland. We say that's a live issue in that regard. And we say that the Secretary of State's willingness to look at evidence in those cases, even if there isn't a residence card, looking at other evidence of the relationship, we say in the context of this case that is discriminatory. And non-discrimination as a general matter is knitted in to the fact there's Article 12 of the withdrawal agreement, but it's a general thread and a theme that goes through the withdrawal agreement.
Yes.
And last, at ground 12, the upper tribunal erred in its approach to the issue of fairness and public law. I, of course, bear in mind the observation of Lord Justice Singh that judicial review has not been sought. But we say that it doesn't matter where there's a statutory appeal designed to look at all the relevant angles and aspects and evidence. And we say that fairness must inform decisions in these cases under proportionality or otherwise. And I won't go through them because they've already been summarised earlier in the skeleton. But there were various other concessions made by the Secretary of State for other categories of immigrants and applicants. I've summarised those at paragraph 34. Those policies are in the bundle. There were also concessions within the EU SS guidance. For example, for those that couldn't obtain evidence of their nationality and other evidence from abroad, from their embassy due to COVID, there's a whole host of COVID-19 exceptions within the Appendix EU guidance, and there are a variety of other concessions, policies, including that if you weren't able, if you were here as a fiancé but not able to get married, then your leave is extended. We say that's.
Is that in the case of non-EU nationals?
Yes, I think that's yes, under the immigration rules.
Yeah. Can I just ask you more generally about Ground 12 and how it fits into the structure of your submissions? Because earlier today you reminded us that the jurisdiction of the first-tier tribunal is to consider an appeal where either something is not in accordance with the rules, the domestic rules, or it's in breach of someone's rights under the withdrawal agreement.
Yeah.
And so far, I think you've been majoring on rights under the withdrawal agreement. Although to some extent you've also made submissions, I know, about the Appendix EU. But when it comes to Ground 12, which is reliance on general principles of public law, how does that fit into the jurisdiction of the tribunal?
The fact that concessions, policy exceptions are made by the Secretary of State as a result of the pandemic, the fact that before the Secretary of State or before the first-tier tribunal judge or upper tribunal judge, there is a case which founders, on a strict reading of the rules and the withdrawal agreements, for the reasons which the appellant relies on, that informs proportionality. But I do take your Lordship's point. The submissions there at 103 to 106, perhaps not decisive to the appellant's case, but they are there. So we say that the appellants, that the upper tribunal got it wrong for all or any of those reasons. The appellant's case awaits lawful decision applying the law properly. And I would just briefly mention the appellant's fresh witness statement. We say we've made submissions about the relevance of this, and we say look at it in the round, the Bini essay, in the round, and sorry if I can just find it. I just wanted to say one word about it, really. I mean, it's a short statement, but I draw particular attention to paragraph 4. I was not aware of this. Clearly not, otherwise things would have been very different. But that's the story in this case and many others.
What bothers me again is that this rather suggests that Mr. Celik wouldn't have made an application in whatever form, whatever document he used, because he didn't think his relationship was enough for it to be durable. But you would say, well, that was for the Secretary of State. He may not have had confidence, but he can't say it is. He thinks it's not, but he could have been lucky with the Secretary of State, and she may have said, yes, if 8 months is durable.
Yes, my learned friend says, augmented by the intention to get married. That's a significant factor. But in any event, it goes back to the point I've made, and I would just say it's very different if you know that irrespective of whether your application is strong or otherwise, that you have no choice but to make a certain application, otherwise you fall off a cliff edge. And that has never been made clear in my submissions sufficiently to avert these cases and this situation. My Lords, those are my submissions.
Thank you very much. Yes, Mr. Mayor.
Thanks to the generosity of Lord Justice Lewis, I've got 45 minutes, but since my learned friend has made such good progress, I might, with the blessing of the Tribunal...
Lord Justice Moylan may overrule me, he's in the chair.
I say that because I do want to open both some authorities and some domestic legislation, my learned friend.
I think you have more time than that.
I'm grateful. Now, I know you've read the skeleton arguments, and I know the subject matter, particularly legally, is very dense. This is the second case under Part 2 of the withdrawal agreement to come before this court. The first case was heard in March. 3 out of the 4 of the front row appeared in that, and a judgment from Lady Justice King, Lord Justice Green and Lord Justice Dingemans is probably imminent in that case, 18. It does have some thematic overlay with some of the issues in this case, in particular, how to go about interpreting the provisions of the withdrawal agreement, the operation of the Charter and general principles of EU law. And like the court in that case, you have the benefit, or benefit it surely is, of the judgment of Mr. Justice Chamberlain sitting with Judges Ward and Wright, all three very much experts in EU law in the tribunal decision in that case. And it certainly engages with some of the issues in play here. Now, there are, from our perspective, 3 topics of legal concern for my 2 clients. They're 3 interlocking topics, and they are these. The first is the proper interpretation and application of the withdrawal agreement in a case such as the present. And that turns, we would submit, in particular, upon the understanding and operation of Articles 10.3 and 10.5 of the withdrawal agreement, as read with the rest of the provisions in Part 2, interpreted through the lens of the requirements of Part 1. And let me be quite plain. Our case is put solely on the basis of Article 10.3 and 10.5. We make no case on the basis of Article 10.1, 10.1e or otherwise. This case is all about durable partnerships. And you will have already understood our secondary point is that the impact or relevance of COVID in all of this is as to the relevance of consequential actions, because we say that in the process of assessing durable partnerships, the fact that the couples who were prevented from marrying and thereby acquiring the automatic or declaratory rights under the scheme of EU law before IP completion day, the fact that they saw through that intention as soon as possible thereafter must be relevant to the assessment of the durable partnership before IP completion day. So that's the first topic. The second topic is the interaction of those withdrawal agreement obligations with the pre-existing national regime, a constitutive regime here for the conferral of extended family member rights, and in particular, the interaction with Regulation 21 of the 2016 regulations. Because what we submit has happened here is that a provision, Regulation 21, designed in really quite a different context and for quite a different purpose, has, because of its application to the scheme of rights in the withdrawal agreement, acquired the nature of a drastic, disproportionate, and quite unfair cliff edge. The third point is that as a consequence of that cliff edge, the claimant has not had the very thing that the withdrawal agreement and Article 3.2 of the Citizens' Rights Directive, which it copies out word for word, insists upon, and has been insisted upon by the two CJEU cases grappling with the requirements of Article 32. That is, individual consideration of the facts and circumstances of his case to assess whether or not he was in a durable partnership. Now, those are all pivotal topics because they are at the heart of the upper tribunal's ruling in this case. And the heart of that ruling is at paragraphs 50 to 60, as we shall see. And the essence of Mr. Justice Lane's reasoning was that the claimant was outside the scope of the withdrawal agreement because he had never made an application that fell within Article 10.3. And that being so, the claims and the attempts to redress it as a proportionality challenge failed. So central to this case and the upper tribunal's conclusion is its view that Mr. Celik was not in scope of the withdrawal agreement, such that Article 18 had no application to him. We say the upper tribunal was quite right that Article 10.3 was the only material provision in play. And we say where it fell into error was for the following reason, because it applied effectively two conditions: an application for facilitation had to in fact be made before the IP completion day. That's the first requirement. And the second requirement, and this is the critical one, is that the application had to be validly made under domestic law. Now, there is, as I apprehend it, no real debate about the first condition, because it's plain that ineptly, maybe, by the wrong form, maybe, but nevertheless in substance, Mr. Celik attempted to draw upon the durability of his partnership as the basis for his entitlement to remain in the UK, and he did so in August 2020. That's before the 31st of December 2020, the cut-off date under Article 4.3. And I think it's tolerably plain if you look at his first application. The basis he identifies unmarried partner, the materials that he's exhibited identical and we're told in both applications 1 and 2, which are all directed at his cohabitation, that what he was saying in substance is, I'm the unmarried partner of an EEA national exercising treaty rights. It's the second condition with respect where we part company with the upper tribunal, and that's because we say, and this is really the critical point of the departure, a defective application as a matter of national law is nevertheless a sufficient application to bring you within scope of the withdrawal agreement. And the reason we say that is because ultimately, while the constitutive regime permitted by Article 10.3, and for that matter Article 3.2 of the Citizens' Rights Directive, is principally a creature of national law, it is a creature of national law plainly bounded by and controlled by requirements of EU law. And the CJEU case law, Raymond and Banger, make that very clear. You can't settle any domestic scheme with any conditions you like, no matter how harsh or no matter how unconnected they are to facilitation. EU law operates as a residual background control. And that being so, if the point that you have failed upon is effectively a cliff edge, an arbitrary or harsh procedural rule, and that violates principles, general principles of EU law, it means that the national law scheme offends requirements of EU law and should be disapplied. So we say the critical fact is that even a defective application is enough to bring you in scope, and once you're brought in scope, that triggers controlling EU general principles, like the principle of good administration or like the principle of proportionality. And indeed, more particularly, it triggers the precise procedural rights identified in Article 20 of the withdrawal agreement that you haven't been shown, that apply to all decisions affecting rights in relation to Part 2. Now, I liaise very closely with my learned friend, Miss Ward. The way that we're going to divvy up our submissions is that I'm going to fully open those points of substance, and then I can almost feel the anticipation. Miss Ward is going to deal with my Lord Justice Singh's procedural points. It's ground one of my learned friend's answer to our case in her skeleton, namely, how can you make these arguments when you haven't challenged the final decision in March 2021, and this is a case all about the second decision, and we've liaised in relation to that, so Miss Ward will be addressing that topic.
Is somebody going to address the topic of what the decision was? I've been trying to find it, but the first decision, I thought they didn't say we're rejecting your application because it's invalid. I thought they said we are refusing it because you don't have a residence permit. Miss Ward, somebody deals with it, that's okay, yeah.
But you'll be unsurprised to hear that prominent in our collective answer to that procedural point is the content of the second decision, which in fact reopens this whole topic.
Because the application...
And addresses it on its merits, effectively reconsidering the whole issue of durable partnership.
Can I just check that that's correct? They certainly have paragraphs, as my Lord Justice Singh showed us this morning, dealing with durable relationships.
Yes.
But they were only dealing with the second application. They weren't reopening the first, were they? Because the second application fails to meet the time point.
They're reopening the topic of durable relationship.
And were they reopening the first application?
The difficulty...
Wait for Miss Ward's answer, tempting as it is.
It may be that Mr. Ward is going to address this, but the problem with the way you just put the point, Mr. D'Alembert, seems to me to be the second decision was on a second application which was made after the relevant date.
Yeah.
Understand the point my Lord is making, and we will answer it.
Tomorrow.
Tomorrow.
Thank you.
So, can I walk you through, first of all, the withdrawal agreement, the Citizens' Rights Directive, which I think it's important to look at the same time, given how directly its provisions are lifted, almost word for word, the 2016 regulations and the relevant CGA case law, which is really Raymond and Banger. So with the withdrawal agreement, it's tab 47 of the authorities bundle, starting at page 1260. And I'll endeavour not to go back over, or at least not go back over unnecessarily provisions Mr. Hawkin has already shown you. On our account, the relevant review starts with Article 2 in Part 1, which are the general provisions, and the all-important definition of union law. And union law is defined to incorporate, this is page 1262, the various treaties, the TEU, TFEU, etc., and the Charter of Fundamental Rights of the European Union, that's expressly identified at 1. And if you look at Little Roman 2, the general principles of the Union's law. So both the Charter, so far as it is capable of being material, and the general principles of Union law are identified in the definition of Union law. Then you have Article 4, at page 1263, and this has been picked over by Mr. Justice Chamberlain in the AT case I mentioned, and it's probably helpful to read its provisions with that judgment in due course to hand. The first part, Article 4.1, is an obligation of uniform result across the EU. And in part, that obligation of uniform result is achieved through the doctrine of direct effect. And for what it's worth, there is no doubt that the provisions of the CRD are directly effective, including even the procedural obligation in Article 3.2, the one we're concerned with, procedural obligation to give due consideration to the individual circumstances of a putative durable partnership. But as AT concluded, the obligation of result is wider than the simple technique of direct effect designed to deliver it. Then you have the obligation on the UK and its various organs, including this court, to disapply any legislation inconsistent with the contents of the treaty, and Article 4.1 and 4.2 are effectively delivered by Section 7A of EUA 2018 as amended. Then Article 4.3, which has been the principal battleground in the AT case, concerns how to approach provisions of this agreement referring to union law or to concepts or provisions thereof. And as we'll see, all of the provisions that we're looking at, in fact, lift directly from the CRT. So Article 4.3 is unambiguously in play. Once it's in play, there is an obligation to interpret and apply those provisions in accordance with the methods and general principles of EU law. And on the strength of AT, on the strength of the reasoning it contains, we say that that means that you, if necessary, supplement the text with the general principles of EU law or considerations favouring one construction or approach over another, derived from the Charter and rights that are enforceable thereunder, including, as my learned friend mentioned, considerations like family life, which are obviously important in the context of durable partnerships. 4.4 then requires you to apply the pre-existing CJU case law before IP completion day, and that is the material obligation here because both Raymond and Banger are cases from the early teens and therefore fall squarely within 4.4, and you don't have to worry about 4.5 because there's no post-IP completion day jurisprudence of any note. Then you have Article 5, my learned friend took you to that, and it is the treaty-specific analogue of the Vienna Convention principles.
Does that have direct effect?
Does Article 5 have direct effect? It has direct effect, I would suggest, in exactly the same way as Article 4.3 TEU does, the duty of sincere cooperation. It's either directly effective...
direct effect.
Well, it's used in order to assist in the interpretation of provisions.
Yes, but that's different from direct effect. I thought I'll have to go back and look at the case law, but I thought 4.3 wasn't directly effective. It might be used to supplement other provisions, but there's case law on it. Anyway, it's not going to turn on that, but just to be accurate.
I think my answer would be, whatever has been done with Article 4.3 TEU, it's the same. It's a means to assist in divining what the underlying intention of the contracting parties is, and that may well be an exercise that results in an obligation that's directly effective being identified. Then you turn to Part 2, citizens' rights. And of course, Part 2 embraces both immigration and social security. And both of those titles, Title 2 and 3, have the same sort of schema, which is that the first exercise you have to do is to look to see whether or not someone is within the personal scope of the withdrawal agreement. And then, having identified whether or not someone is in personal scope, you look at the rights that are conferred on them by the rest of the provisions of the part in order to work out what the substantive position is. And what's unusual about the position of extended family members, what's unusual about the provisions of Articles 10.2 through to 10.5, is that they result in a wrapped-up assessment or appraisal of whether or not someone's in scope and whether or not they have rights. And you can see that most clearly from looking at Article 10.2, because what it says is if you've got a decision conferring extended family membership upon you pursuant to the provisions of Article 3.2, you shall retain the right of residence in the host state in accordance with this part, provided that they continue to reside in the states thereafter. Whereas the structure of the other rights, or the other provisions, Article 10.1a through to F, is just simply directed at the topic of are you in scope. The rights that you have are then conferred by Article 13 and other provisions within the withdrawal agreement.
But isn't that the result of them being a right derived from national law? You don't have, as an extended family member, an EU right to residence. You have an EU right to have your position facilitated. And if a right is given to you to reside, the legal source of the thing that entitles you to say to the immigration officer, I can come here and live here, is the piece of paper issued by the national authority.
Broadly, my lord, I agree. Of course, the scheme of most of the rights codified by the Citizens' Rights Directive, which is itself a fleshing out of the underlying treaty rights, is a scheme of declaratory rights. And undoubtedly, what's unusual about Article 3.2 extended family membership is that it is a constituted scheme in exactly the same way that Article 18 is a subsequent constituted scheme.
When we say constituted, what that means with those words
is that there is a role for a national discretionary decision pursuant to national legislative provisions. But
bounded by EU law, but there's got to be a national decision
absolutely
to grant the right of residence.
Absolutely, but the critical thing in what my lord's just said is bounded by EU law. It's not a topic wholly out of scope of EU law. It's a topic controlled by EU law, where EU law does not supply a wholly uniform answer, because different member states can take different approaches to what might constitute a durable relationship, and that's perfectly permissible. So the key words there are bounded by EU law. The scheme of 10.3 through to 10.5 is effectively one that catches those cases that straddle IP completion day. You make your application before IP completion day, but it's not resolved before that date. There's a transitional regime, and it's one in 10.5 that insists upon an extensive examination of the personal circumstances of the persons concerned. That language is a word-for-word copy of the language in Article 3.2 of the Citizens' Rights Directive, the last provisions. I'll show you that. It is a word-for-word copy. And where you get to, therefore, is that the critical provisions here, Article 10.3 and Article 10.5, are both provisions squarely caught by Article 4.3 because they draw upon union law concepts or provisions thereof in order to identify the rights conferred. Now, I've used this analogy before. I can't remember if I've used it on my Lord Justice Lewis, but the way that the withdrawal agreement works is a bit like an EU Lego toolbox, and you take familiar blocks of EU Lego in various places and you recycle them in the withdrawal agreement. And where you have used an identifiable EU Lego block, as is the case with 10.2 and 10.5, it's then that Article 4.3 says it's usual EU law that applies, you apply general principles of EU law, etc., you interpret it just as it were, had it still been EU law. The reason why we say it's 10.3 or bust is because of the careful definition in Article 9, 1265 of family members. And as you probably heard me interjecting, it's been defined explicitly to exclude extended family members. And that being so, with the best will in the world, and we understand where the argument advanced by my learned friend comes from, it's impossible to construe the concept of family members in the kind of extended fashion my learned friend urges upon the court, because the terms of the treaty in this respect are careful and clear. This case, we say, has to be about durable partnerships. Of course, given the role for discretion bounded by EU law, the facts of COVID and the facts of subsequent marriages and inconveniences, etc., are all going to be critical to the fact-sensitive assessment under Article 10.5. So that's the relevant provisions dealing with extended family members. You then have Article 18. Now, there are a number of things to draw from Article 18. Article 18, just like Article 3.2 CRD, is another constitutive process. And we say it does send, now I hope this isn't too vague, it does send tonal messages clear indications as to how EU law will approach the bounds that EU law sets upon the permissible terms of the national constitutive process. And doing so by reference to Article 18, it is, we say, most unlikely that the logically and legally prior constitutive process created by Article 10.3 and 10.5 should operate in a fundamentally different way. That is not, as my learned friend Ms. Smythe has accused us, to conflate the two processes. It is to say that you can learn from Article 18 what the treaty drafters' intentions were and make proper and rational inferences as to how they expect Article 10.3 and 10.5 to work at the legally prior stage. And the lessons that you can learn from 10.5 is that there are deadlines. There are deadlines in Article 18, just as there is a deadline explicitly in Article 10.3. The deadline explicitly in Article 10.3 is you have to make your application for extended family member facilitation before the 31st of December 2020. That is the deadline contained in Article 10.3, and we and the Independent Monitoring Authority are agreed upon that. But Article 18, and we went through this earlier, 18.1d, in particular shows that deadlines can and should be softened where effectively it's outside your reasonable power to comply with the relevant deadline. But then, perhaps more importantly, it's the provisions at L and O.
But before you get, could you just look at 18.1 with me, which is something that I'm puzzled about. The host state may require union citizens of United Kingdom nationals, their respective family members, those are spouses, and other persons, well, that must be people like extended family members.
It must, yes.
Who reside in its territory,
Yes.
in accordance with the conditions set out in this title. Well, extended family members wouldn't be residing in accordance with the conditions set out in this territory because there's nothing in this title to deal with that. That comes from national law. And then to apply for a new resident status, which confers the right under this title, well, this title doesn't confer rights on extended family members, and a document evidencing such status. And I've still been hung up on the fact that you don't have a right of residence under this title. What you have is a right under EU law to have your application for a national residence card facilitated, and that's what Article 10, 3 and 5 are. But
my Lord is making a characteristically careful point that this title starts at Article 13.
Yes.
And because of the structure I've identified earlier, the peculiar nature of the
Yes.
EFM rights, that they're they come in Title 1.
Yeah.
And my submission in relation to that is that it's plain that that is a drafting mistake, because otherwise the words other persons make no sense and could have no conceivable application.
And other bits of
And what is more,
yeah.
that is also plain from the contents of 18.1L that grapples explicitly with the position of extended family members, and it explicitly shows that the intention is, as the Secretary of State says, and as we agree, a two-stage process. Stage one, establish your rights either before Brexit or under the withdrawal agreement, under the Article 3.2 process or its analogue in Article 10.2, 10.3 and 10.5. That's stage one. Stage two is having those rights and having a residence card. You present the residence card in the constitutive process to convert that which was formerly principally a creature of EU law into a domestic new right where the member state has exercised that right.
That's what I thought. I mean, I'd come to the conclusion that it looked as if Article 18 was setting up a new status, and the status was meant to transfer the rights that you'd already got. But the problem is you haven't got any EU rights. You've got national rights. Wow. But if that's the case, it seems to be saying that there are two things that have to happen. You have to have a residence card, and then that's, whatever that gives you, if it's, as in our case in the United Kingdom, up to 5 years, that's what you get under the new residence status. And indeed, all you can ask for, I think, is the residence card under L, but you will tell me that that's a mistake. So it looks as if they're assuming you've got a national residence card, and what 18 is about is telling you to turn that national card, say it's 5 years under your current national card, into your new all singing, all dancing EUSS card. Whatever's left of the 5 years will be turned into your EUSS.
Of course, the principal focus, the overwhelming focus of this article is people with declaratory rights.
Yes.
Who've never had pieces of paper. That is the overwhelming focus.
Yes.
And so we've got to be careful not to have our optic moved by this particular sub-cohort of cases. But the analysis in relation to those with extended family membership is, we accept, one in which the first exercise is to establish, under the national procedures bounded by community law, your entitlement to be given the residence card. That's stage one. And stage two is to present that residence card and say, I'm now entitled to have that former creature of the Citizens' Rights Directive, because it was a creature of the Citizens' Rights Directive, I'm entitled to convert that now into, in this case, limited leave to remain under the Appendix EU, and a purely national right of residence.
How do I know what you get? Say I've got indefinite leave to remain. Say I've got a residence card which is 2 years old.
Yes.
So I've got 3 years left under that.
Yes.
What do I convert?
You convert into limited leave to remain because
how long?
You won't have been here for 5 years.
Yes, but is it for 3 years or for 5 years? And then there's no 3 years.
Well, it would be, you'd get it, I think. I'll take careful instructions on this, but my understanding is you'd get it for 5 years, but you'd be entitled after whatever the balance is to effectively have it upgraded into indefinite leave to remain. All of that is, of course, bounded by the decision of Mr. Justice Lane in the RIMA case, in which he said that what can't happen is that you lose your entitlement by dint of a failure to make a second application.
Yeah, I understand that. Mine is a difficult, more mechanical question at the moment. I'm trying to work out how it works. I understand how it works for somebody who's an EU national,
Yeah.
or for somebody who's the spouse of an EU national, because I can read Article 13 or
Yes.
50, and I'm just trying to work out how this Article 18 is meant to work for something where the right comes from national law. There's nothing in the legislation that tells me give the balance of the residence card.
No,
I just got to imply it.
So what would happen is you would have made your application under the 2016 regulations, which we'll come to.
Yeah.
You'd have got what you're entitled to under the 2016 regulations, which is a 5-year residence card, subject to conditions of a continuing entitlement.
Yeah.
And once you've got that 5-year residence card, you can then convert it into ILR. And there's nothing about...
No, I'm not concerned about converting it to ILR. I've only got 1 year left on the card.
That's enough.
And no.
I'm so sorry. I should let
It's quite a different question.
I know you want enough to read. I'm so sorry.
It's a very, very different question.
Yeah.
All those are very interesting questions, but my question is a different thing. And the reason why I'm asking is I'm trying to work out which bit of this treaty do I look at. I got a card in 2016. It's now 2020. I've got 1 year left on the card. And I go to the immigration office. I want to know two things. How long do I get into the USS? Do I get 1 year left and then I wait for the 5? And if it's 5, not 1, and the immigration officer says, oh no mate, you're only having 1, what do I point him or her to say it's 5 years? I can't find the mechanism, basically, for translating the national right into the equivalent EUSS right, or is that in the EUSS?
It's in Appendix EU.
It's in Appendix EU.
Appendix EU. It's not provided for by the withdrawal agreement, because the withdrawal agreement merely permits you to create a constitutional
So I'll find it in the EU. If I apply
Yes.
for it first time round, I'll get it for 5 years.
And basically, under Appendix EU, you either get 5 years limited leave to remain, or you get indefinite leave.
So it's not dealt with by the treaty, it's dealt with by each individual
Right.
national set of legislation, and in the United Kingdom, that's the EU.
And I am reassured to see Miss Smythe, knower of all things in this connection, nodding her head. So it must be right.
With what you get, yeah. Thank you, that's very helpful. That's all I wanted, Mr. Dillon.
I'm so sorry. Trying to be too clever, as per usual. I'm getting ahead of myself, as usual. So L is the clearest pointer to the fact that these cases are within the constitutive scheme, notwithstanding my Lord's well-made drafting point about the beginning of the language. And then O is, we say, a very clear signal that these processes are to be operated in a sensible, proportionate and collaborative fashion, so as to lead to the conferral of rights rather than their denial on technicalities. Now, if that's true in relation to the Article 18 process, as it undoubtedly is, we say the same logic and force applies to the EU bounding controls exercised over the Article 10.3 extended family member process. That's our case. We're not conflating the two. We're not saying that they're the same. We're saying that you can learn from what is contained in Article 18 as to what EU law thinks or does not think, or what the drafters more accurately of this agreement think or don't think, as to what is or is not an acceptable approach to any such constitutive process. Then you have Article 18.1r, and as we shall see, that is no more than a guarantee, even in the context of the national constitutive process, that it will still be subject to an EU law remedies guarantee. Now, the reason I put it like that is because you will see exactly the same language ultimately produced by Article 20 of the Withdrawal Agreement. The purpose we infer behind Article 18.1r is to make it plain beyond argument that even though the process in question is a national constitutive process, EU law type controls still apply as to the quality and nature of judicial control or supervision that must be supplied with it. Now, the reason we say that is because of the provisions of Article 21, which we address at some length in our skeleton argument. Article 21 simply says the safeguards set out in Article 15 and Chapter 6 of the CRD shall apply in respect of any decision by the host state that restricts residence rights of the persons referred to in Article 10 of this agreement. And that means that Article 21 applies to decisions under Articles 10.3 and 10.5. It's a guarantee that applies even in relation to decisions about durable partnerships. So, at that point, it's probably sensible to go to the provisions of the CRD. The CRD is the next document in the authorities bundle, tab 48, page 1288. We can rattle through its provisions. You have the, I suspect, familiar definition in Article 2.2, page 1299, of family member. That's the narrow definition, which is not met by a durable partner. And then Article 3, page starts at 1299. You have those who have automatic rights, because they are family members, narrowly so defined. That's the conventional declaratory scheme of EU law rights. And Article 3.2, that's us, without prejudice to any right to free movement and residence, the persons concerned may have, in their own right, the host member state shall, in accordance with its national legislation, facilitate entry and residence for the following persons, and then B is the partner with whom the union citizens has a durable relationship duly attested. And then this language, the host member state shall undertake an extensive examination of the personal circumstances, etc. That is the language lifted word for word into Article 10.5 of the Withdrawal Agreement. Then we go to Article 15 of the CRD, that's at page 1315. That is the provision incorporated by reference in Article 20 of the Withdrawal Agreement. 21, quite right. And it has another renvoi.
So which article are you in now?
Article 15, page 1315. It provides that the procedures provided for by Articles 30 and 31, those are the provisions dealing with public policy-based expulsions, like codification of Bouchereau and all of that case law, shall apply by analogy to all decisions restricting free movement of union citizens and their family members on grounds other than public policy, public security. So what is being said is There are a specific set of safeguards in Article 30 and 31 designed for public policy cases. Those safeguards are to apply by analogy to non-public policy cases. So then you go to Article...
But does that apply to a situation where you're talking about facilitating somebody getting a residence as opposed to restricting a right of residence that they have, i.e. they've got it under the treaty because they're a family member of an EU national, and then you say, no, I'm not going to let you come in for whatever reason?
Yes, it does. Because when one looks at the safeguards, there are two forms. They are procedural. They're a guarantee of an access to courts with sufficient powers to review the decision. And they are substantive in this sense. They're a guarantee that your case will be considered on its individual factual merits.
So restrictions...
So we go to Article 31.
Sorry, just so I've got the solution clear, the words restricted free movement of union citizens and their family members include a decision that they are not going to facilitate entry by granting a national
Yes.
to an EEA, to an extended family member.
Yes, there must be, because that's exactly what Article 21 of the withdrawal agreement requires by express reference back to Article 10. And the types of decisions that are being taken under Article 10 are scope decisions or scope and residence decisions. So we go to Article 31, and that's headed Procedural Safeguards. The persons concerned shall have access to judicial and, where appropriate, administrative redress procedures in the host member states to appeal against or seek to review any decision taken against them. And then the balance of Articles 31, 2 and 3 is as to the minimum content of that redress procedure. And it's 31.3 that is relevant in particular. The redress procedures shall allow for an examination of the legality of the decision, as well as of the facts and circumstances on which the proposed measure is based. They shall ensure that the decision is not disproportionate, particularly in view of the requirements laid down in Article 28. So it is with respect here, in this case, that you locate a concrete, hard-edged EU law obligation to act in a proportionate fashion. We depart from Mr. Hawkins' analysis so far as it's mediated through Article 18.1r, but we say you get to exactly the same place through Article 31.3 as incorporated by reference. There is an obligation of proportionate decision-making. And then the last stage, the fourth step in this merry-go-round of renvoi, is Article 28, which is back at page 1326. 28.1, and this really, it's questionable whether it adds to the contents of Article 10.5 already. It says, before taking an expulsion decision, well, Article 15 says a decision restricting rights is to be treated the same by analogy. The host member state shall take account of considerations such as how long the individual concerned has resided on its territory, his or her age, state of health, family and economic situation, social and cultural integration, etc. So those are the CRD rights incorporated by reference.
So you say those factors are, just go through a bit slow, those are factors that are necessary to the decision as to whether or not to facilitate residence in the context of Article 10.3, because they're brought in by Article 20 and by analogy, and you've got to forget its expulsion. It also says, even if you haven't got it in the first place and we're not taking it away, in deciding whether or not to give it to you, in deciding whether to facilitate, the fact that you have actually been here for X number of months, albeit illegally, but with somebody with whom you have a relationship and looking after child, you say those factors come in through Article 20.
Yes. And what we say is the interaction with the national procedures are, is that if the national criteria make any of those things relevant, because it may be that under your test for durable partnership, the test is easier to satisfy and those things aren't relevant. But insofar as that form of factual appraisal is relevant, then those considerations become mandatory relevant considerations in each case. You have to do fact-finding. It's a fact-finding obligation. And that's where you get to at the end of this trawl through the legislative procedure. The absolute paramount obligation, the directly effective component of Article 3.2 rights, is a procedural obligation. Not a substantive obligation, it's a procedural obligation to find the relevant facts and to make a determination on the merits.
Is it only procedural? What I have in mind, is, and I stress that this is a purely hypothetical scenario, but as you know, courts ask hypothetical questions in order to see what the boundaries of principles are.
Of course.
But suppose you had, hypothetically, a national scheme which was utterly offensive for some reason. For example, it discriminated on racial grounds or something of that sort.
Yes.
And said that whatever else may be true on the facts of your case, this will not constitute a durable partnership because your partner is black.
Yes.
On your submission, would EU law control those national requirements?
Yes, it would. It would. And the reason being that this is a decision clearly within the scope of EU law. And as such, either the Charter or EU law general principles operates to control that which is permissible. It's a decision within Article 50 of the Charter, and the case law in relation to it, within the case law about the application of general principles. And we'll see that from the case of Bangor, because it makes, and Raymond, makes it absolutely plain that whilst there's a very hefty measure of national discretion as to what rules to set, they are still bounded by EU law. And ultimately, it still has to amount to facilitation in some form within the ordinary meaning of that particular term.
In one sense, all of this is interesting, but irrelevant. Because had the appellant applied for a residence card in August 2020, they would have had to ask, is there a relationship? Is it durable? Is it 2 years? Or if it isn't 2 years, is there other evidence that shows it's durable? And they would have done that without any shadow of a doubt. And the issue that we're dealing with, and you may say these things are exactly the same, it's whether or not it's lawful to treat an application for a new residence status under 18, or in accordance with 18, is it lawful to say, well, you made that application and you haven't got a residence card. And if you wanted a residence card, you should have applied for a residence card. And we are going to say that it's unlawful, contrary to EU law, not to treat an application said to be for one thing, and it says it at the top of the form, as an application for another. That's all you've really got to deal with. So although this is extremely fascinating, especially for some of us, the key question, isn't it, is was it in any way a breach of something not to treat the application form in August 2020 as an application for a residence card?
I don't demur from that at all,
Yeah,
my Lord.
that's the real issue.
I completely agree. That is the big issue. But actually, you need to have the relevant analytical framework of operative controlling principles established first. And where that debate gets you to, actually, as we'll see, is Regulation 21. Because Regulation 21 is a very strict rule that says unless you make an application using a prescribed form and fully complete it and do X, Y, and Z, any application made will be invalid. And I'll show you that provision in question. Its logic, its express legal requirement, is that if you even omit so much as the postcode that the form requires, or if you, in your mistaken hurry, transliterate wrongly the card number on your credit card, and you reverse 2 digits in the way you write it down, and your payment is refused, your application is invalid. That's what the rule says. And that is, eventually, where we get to. That is the eventual target. And it's not me saying that. That is the consistent analysis of Mr. Justice Lane, in this case, paragraph 53, the reason why he said there was no valid application under Article 10.3 of the withdrawal agreement is because the application made using the wrong form was invalid under Regulation 20.
And that's what he said, yes.
It's also what he said in the Batul case, paragraph 68, I recall. And it is the rock that every claim like this will necessarily fail upon if that rule is valid. And that, as you'll remember from this morning, it was that very point that Here for Good made in the second of the letters written to the Secretary of State. That very point was flagged.
But going back to what I said earlier, if the question is, was it lawful not to treat the EUSS application as a residence application, the reason why it's not lawful as a matter of EU law is what?
Is because, as a matter of EU law, to apply a rule that says if you use the wrong form, we will treat you as never having made an application, such that you face a cliff edge, given the time limits that are in play, the 31st of December 2020 cliff edge, that produces a disproportionate effect. That is also a violation of the principles of good administration. What should have happened, as a
If you
matter
use the wrong form, we will treat you as never having made an application. That's a breach of
it's either disproportionate, contrary to the general principle of proportionality, or it's contrary, as we set out in our skeleton argument, to the general principle of good administration, which binds member states acting within the scope of EU law. See the Zachem case. That's not put on the basis of the Charter, general principle, applicable within EU law. To take that effectively, computer says no approach to a decision of this importance contravenes both principles. What should have happened is that the individual applicant should have been said, you're obviously trying to do this, this is the logically first step, please complete this form, we'll then consider it. If you qualify under this, you'll then have your Article 18 application considered. That would have
You're
been...
obviously trying to stay in the UK and we'll consider it on that basis, and anything else would be a breach of proportionality and
Yes,
or
it's
administration.
grossly disproportionate, because what it's done is it's transmuted a regulation designed for one purpose, Regulation 21, in a wholly different context. So think back to 2012, 2013, what would have happened then? If you'd made the wrong application then, you'd have simply reapplied. Indeed, the form says as much. Page 5 of the form Ms. Smythe has helpfully provided says, if you muck up this form, your application will be treated as invalid. We'll dock you £25 from your application fee to cover the defective form, a process that seems to have no legal basis, but let's put that on one side. We'll dock you £25 and you can resubmit your form. And of course, that's what happens before this whole process takes on its cliff edge function in 2012, 2013. If I fail to put in the postcode, if I don't make the proper payment instructions on my MasterCard or whatever it is, form comes back to me, I lose £25, I resubmit the form, I go again. And what has happened is that the national regime has been persisted, notwithstanding the fact that it has attracted a massively different consequence once it's being built upon for Article 10.3 and 10.5 Brexit purposes. And that's how the disproportionality has intruded. Prior to Brexit, an argument directed at Regulation 21, we accept, would be extremely difficult because the consequences are utterly manageable. But once you build upon those processes to comply with Article 10.3 and 10.5 obligations, and you create procedural cliff edges like that, they become obviously disproportionate. And with respect, you all know enough of the CJU case law to know what the CJU would say if you said, if in consequence of having used the wrong form, or not having put in your postcode, or transliterated your credit card details wrongly, you lose all the rights that you would otherwise have that the treaty is meant to guarantee you. Is that proportionate? I think we all know what the answer the CJU would give to that question. Yes, it obviously is.
So if you sent the form, the Secretary of State finally got her act together and sent it back in October rather than waiting till after the poor chap couldn't apply again and said, no, wrong form, use the right form, it would have been okay, but not because of the consequences. It's the fact that after the 31st of December, if you haven't taken a decision by that time, the consequences are grave.
Yes, and one only needs to think about the interplay with the points my learned friend has made about COVID to see the types of dilemma people may have had at the time. What is undoubtedly true, and there's evidence from Mr. Evans and Mr. Mosselman, Miss Mosselman, etc., saying that the COVID problems are a very real problem, whether it's through restrictions or backlogs in marriages through restrictions. Your strategy may well have been, until it became quite apparent that it was going to be too late, to marry. And you may have had to, in consequence of COVID, made the durable partnership applications very late indeed, because you might have even had a date in Bromley Registry ready to go, only to have it pulled and cancelled on you at the last minute. And in those circumstances, to say, well, too bad, when you made your application 2 days after your appointment to get married was cancelled, you failed to put in the postcode, or you used the wrong form, you did this and that and the other. Too late, too bad, you've lost everything. That is obviously disproportionate. And to that extent, we completely agree with everything my learned friend has said on that front. Where we differ is the legal hard edge we rely upon to get to that crunch question. So, can I show you the case law very quickly? Banger and Raymond. Rahman is a 2012 case. It's authorities number 6. Page 214. You can see the questions referred at paragraph 17, page 241.
Sorry, can you start? You were going to take us to the regulations. Are you not?
I'm taking you to the CRD provisions, case law first.
Okay.
Because this is CJU case law on the CRD.
Okay.
Then I'm going to take you to the domestic regulations.
Right. Which bundle?
Authorities bundle tab 6.
Thank you. Yes, thank you.
You see the UT referred 6 questions, and in characteristic fashion, those questions are reformulated by the CJU. And the ones we need to look at firstly are questions 1 and 2. And if my lords haven't read this passage already, could I just ask you to read 18 through to the end of 26, the red highlighted passage. And then I'll make some quick submissions on it.
Yes.
So 2 things I'd ask you to note in particular. First, the thrust of this is very plain. The principal guarantee provided by 3.2 is of individual consideration of each case on its facts. That's the procedural guarantee, the directly effective component of Article 3.2. The second point to note is that whilst the concept of facilitation is wide, and whilst member states have discretion as to what criteria to use to approach that particular topic, it is still a topic bounded by the term facilitation, and critically, as the end of paragraph 24 makes plain, bounded by the EU law principle of effectiveness. Because they say that whatever the national rules do, it still ultimately has to be facilitation within the normal meaning of that term, and the provisions must not deprive that provision of its effectiveness. And that particular requirement of effectiveness is reiterated in the dispositif in 26 in the penultimate bullet, and indeed in the answers disposing of the question. So that shows that the whole process is bounded by EU law. What the CJU hasn't had to grapple with is criteria that offend on one of the standard grounds there might be offensive as a matter of EU fundamental rights principles: sex discrimination, race discrimination, sexual orientation discrimination, nationality discrimination, etc. But the answer is obvious. If you encountered that, it would be within the scope of EU law, and it would be amenable to challenge on that basis. And that must be so, because anything else would threaten the uniform nature of the guarantee required by Article 3.2 in any event. The second passage of relevance is the answer to question 5. Question 5 asked about the nature of dependence that's required. And the answer is again given that A, as the Advocate General has indicated, Member States may, in the exercise of discretion, lay down their own particular requirements as to the nature and duration of dependence in order to satisfy themselves that a situation is genuine and stable and has not been brought about with circumvention in mind. And the national provisions, when we come to them, contain a definition of effectively a sham durable partnership, which is excluded. And therefore the answer to the fifth question is that Member States may, in the exercise of their discretion, impose particular requirements relating to the nature and duration of dependence. That's no different to the exercise of discretion in relation to a topic of free movement of goods. Generally, the Member States can do what they like as long as they respect the limits set by EU law. So that's Rahman. Banger is then in tab 3 of the same authority bundle. It's 4 years later. Slight procedural wrinkle, as is apparent from holding 1 in the headnote. Banger is in fact a Surinder Singh type case because it involved a UK national with a foreign partner who had moved to the EU, resided in the Netherlands, and was then returning to the UK. And what the CJEU did was decide this case by reference to his free movement rights, because strictly speaking it was outside the language of the directive, but drew a direct, almost automatic analogy with the requirements of Article 3.2 to flesh out what his free movement rights in those circumstances were. And that being understood, you can then see holding 2 refers to Article 3.2 of the directive, as does holding 3. So holding 3, which summarises paragraphs 48 to 52, shows that we are dealing with a situation where the remedy by way of challenge, and this was a case about what remedies were available to challenge any decision of this kind, had to be effective. And we can pick matters up at 48, at page 107. So 48 at 131. And here is the explicit answer to my Lord Justice Singh's question. Since the provisions of the directive must be interpreted in a manner which complies with the requirements flowing from Article 47 that's effective remedy, those persons must have available to them an effective judicial review against the decision.
Well, judicial remedy.
Yes, but that's because that was the particular issue at large in that case. The critical point is that the analysis in 48 shows that the Charter applies, and if Article 47 of the Charter applies, so too must all the other provisions in the Charter apply. It just so happens that that case concerned complaints about the quality of the remedy on offer.
Would an appeal to the first-tier tribunal against the refusal of an application such as the one made in this case be an effective remedy?
In principle, yes.
Yeah.
So the Charter applies, so says the CJEU, even though it's a 3-2 scenario. Then at 49, it said it must be found that the procedural safeguards provided for in Article 31(1) of the directive, those are the provisions I've just shown you in the CRD about redress, are applicable to the persons envisaged in point B of the first paragraph of 33(2) of that directive. Now, with respect, that shows that the submission that my learned friend Miss Smythe has made, that Banger shows that the provisions of the CRD don't, in relation to appeal, redress, etc., don't apply to 3-2 cases, is wrong. The passage she cites starts at 50 to 52, yet here, in the very passage before paragraph 49, the CJU is saying that Article 31 does apply to Article 3-2 cases. My learned friend is saying Article 31(1), and as I've already explained, Article 31(3), which is the relevant provision containing the guarantee of proportionality, merely explains what the content of the redress procedure required by Article 31(1) must be. So, Banger is a clear authority for the fact that the full suite of the procedural safeguards contained in the CRD apply to 3-2 cases.
Do you rely on paragraph 50?
I do, it's all helpful.
Because what may be significant in...
Is the words remained within the limits of the discretion.
Well, I was going to say the words national legislation.
Yes.
In other words, this is a form of judicial review which may require not only to ascertain whether the application of legislation has remained within the limits of the discretion afforded by EU law, but may require a national court to review whether national legislation.
That's right, my lord. And the reason for it on the facts of Banger was because of a deficiency, I think, under the rights of appeal conferred in relation to a decision of this kind. And I think I might have said, I can check, that the problem was that the rights of appeal conferred by the EEA regulations, as then set up, didn't extend to this type of case, precisely because it was a Surinder Singh type case, rather than...
So the appeal rights didn't extend to UK nationals returning to the UK. They had no right of appeal.
I think that's the problem.
It was Mr. Delamere looking at me, so I'll explain. What happened was that there was always an appeal right for extended family members, and then the upper tribunal made a decision which construed the regulations differently, and so it was decided that there wasn't an appeal right anymore. And then there were various pieces of litigation about that, whether there should be an appeal right. And essentially the reason for the court answering this question was because it was looking at whether judicial review was a good enough remedy.
So where were we then? Did this person, the man who had gone to Holland and married a woman and brought her back with him, did he have a right of appeal under domestic law, or did he not have a right of appeal?
No, he did not.
So this case was just about whether judicial review would be an adequate remedy. Okay. So does it help us much?
Of course, the essence of the obligation is individual fact-finding. And the difference between a tribunal remedy and a JR, getting to sort of Brian and UK territory, JR may be perfectly fine for ventilating questions of legality and legal policy, but the whole essence of the Article 3(2) guarantee is an investigation of the facts, and the whole essence of the Article 31 guarantee is effectively an appeal on the merits. That was how I understood the dispute. But Yeah, as Ms Ward reminds me, that's made plain by paragraph 52.
I'm not sure how this helps us at the moment.
Well, the way it helps us is in the following propositions that it clearly establishes. It clearly establishes that the Charter applies to Article 3.2 cases, and that any national decision-making process, including the legislation, must comply with the Charter. That's point one. And if it's true of the Charter, it must be true of general principles. That's point two. So that brings with it principle of proportionality as a freestanding principle, principle of good administration as a freestanding principle, see the Zachem case, etc. The second proposition that it helps with is it's explicit in showing that that Article 3.2 CRD process is controlled by the procedural guarantees of a remedy contained in Article 15 and Article 31 of the CRD, which incorporate, as we've seen, Article 28 by reference. And as such, when the withdrawal agreement in its Article 21 refers to those provisions, it's business as usual in terms of the controlling principles governing national legislation.
Probably me, but so what do I, looking at this case, when if one comes to give a judgment or could go the judgment, which bit of banging helps me decide what?
Paragraph 48 establishes that the Charter, by logical extension,
applies to Article 3.2 decisions, and that's it. So
yes, but that's a contested proposition.
oh, right, okay. So that proves that Article 7 of the Charter applies, right, okay.
Not Article 7.
Article 47.
Article 7, not only Article.
Well, it's Article 7 and Article 47 by logically.
Yeah, of course, yes.
Yeah.
Article 7, family life, absolutely right.
41, you would say.
Yes. But the way that we put our case in our skeleton argument is principally on the basis of the principle of proportionality and of good administration. But
Well,
I
the
entirely
second-
accept my learned friend Mr Hawkins' point. If we're into the Charter and we're dealing with durable relationships, then Article 7 is front and centre, because the whole point of the durable relationship exception is to preserve family life in cases of sufficient durability as to merit protection.
So, putting it into the facts of this case, when the Secretary of State came to take a decision on the 2nd of March 2021, she should have applied the Charter, Articles 7, 41 and 47, and similarly, had there been any appeal, the first-year tribunal and the upper tribunal and any further appeal would have had to apply the Charter. Is that it?
The correct response would have been that because of the nature of the obligation here, it was insufficient simply to reject as invalid the decision in question. That's the
The
disproportion.
application, insufficient to reject is invalid, the application in question.
Absolutely. And the
Okay.
basis for the rejection of as invalid is Regulation 21, which is what's my Lord Justice Moylan I'm about to come to next.
But I've got to know, so insufficient to reject is invalid, the application made here in August 2020.
Yes. What should have happened, by hook or by crook,
Should have written back and said, I've read all the Charter, I've read everything else. What you actually need to do is apply for a residence card. Or alternatively, even though you haven't applied for a residence card, I'm going to treat it as if it were.
here's the form, complete it, I won't deal with your application until you've done that and I've considered it. That's what should have happened.
Yeah.
That's
So
in
these-
response to the application in August 2020.
Yeah.
Yes, exactly. So, domestic transposition, it's horrendously complicated. I'm going to give you, and I've made, as has, I think, Miss Ward, errors in my understanding of it, and we've been corrected by Miss Smythe. I'm going to give what I hope is a correct analysis of both the regulations and their transposition and transitional effect in consequence of Brexit. So the regulations are at tab 57 of the Authorities Manual, 2016 regulations.
Sorry, which, which tab I wasn't listening?
Tab 57. start with the definitions. In Regulation 2, you've got a definition of durable partner, and at 1485, over the page at 1486, you've got a durable partnership of convenience. That's effectively the equivalent of a sham marriage. And then Regulations 7 and 8 are the critical ones, present purposes at 1489 to 1490. Regulation 7 deals with the rights of family members, and that's in the narrow Article 2.2 CRD definition. Then Regulation 8 deals with extended family members. And Regulation 8 defines extended family member to embrace various different types of relationship. The relevant one for present purposes is 8.5. That's the durable relationship with an EEA national at 1492. And then you need, having looked at those provisions, to look back at Regulation 7.3, page 1489. A person B who is an extended family member and has been issued with an EEA family permit, a registration certificate or a residence card must be treated as a family member of A, provided that. So,
where are you reading from? I'm sorry, you're just going too quickly for me because I've got to take a note as well.
I'm so sorry.
I was at Regulation 7.5 last when you moved on. 8.5, is it? Yeah.
So, Regulation 8.5 is the provision that says that a durable partnership.
Yeah, I was just reading that to myself. Yes. And then after that, I had to go where?
Then, if you go back to Regulation 7, after the provisions 1 and 2 dealing with the automatic family members, you then have 7.3 that then embraces within the concept of a family member, an extended family member, if they meet various conditions. And the conditions are satisfaction of the definitions I've just shown you in 8.5, as the case is here.
But 7.3 says must have an EEA family permit, which I think you get under another regulation, a registration certificate not relevant, or a residence card under 18. So you've got to have one of those three, have you?
Yeah, provided that you also satisfy the conditions in Regulation 8.5.
Yeah.
And the relevant family permit, registration certificate or residence card remains in force. So it's adopted a different approach to the Article 2.2 definition of family member by effectively folding into the domestic definition of family member an extended family member meeting certain conditions.
And to get a residence card, it's Regulation 18, is it?
That's right. Now, where we went wrong, and my apologies, it's not even in the bundle, such as the error that has been expurgated, is that in our skeleton we referred to Regulation 12, and Regulation 12 deals with out-of-country applications, so it's completely irrelevant. Save to note that one peculiarity of the transposition, and indeed the requirements of the withdrawal agreement, is that the cut-off deadline for those applying in-country was the 31st of December, but if you were applying to bring in a family member, extended family member from out of the UK, in fact you had, I think, until the 30th of June to do so, the following year.
Well, the grace period was not extended to Regulation 18, only to the other things.
Correct.
Yeah, and that was an act of national legislation.
Correct.
In the regulations, and nobody's challenged it, and that's the law, isn't it?
Well, except that the withdrawal agreement does require, as a continuing obligation, that you facilitate entry of family members. So there is an ongoing duty of facilitation, and as I understand it, it would even apply to Mr. Celik, save that what would happen is that he would have to go back to Turkey and remain there for 6 months before he could then apply effectively under regulation, article, the equivalent of Article 3.2 for facilitation in those circumstances. And that's the point made, I think, by the Secretary of State in the letter back in March 2022 in response to...
But in this case, if he had wanted to rely on rights under the 2016 regulation before they were revoked, he would have had to show that he was in a durable relationship and had a residence card under Regulation 18, because he was already in the United Kingdom, albeit unlawfully.
No,
And
he'd
that's-
had to apply for a residence card
Yeah.
under Regulation 18.
Yeah.
And so it's
And if he
actually
got it, he'd have been a family member,
Yeah.
provided still in force and so
it's
on.
Regulation 18 that's the most directly in play. That's the regulation that applies to non-EEA nationals applying to be treated as durable partners. Regulation 17 applies to EEA nationals applying to be treated.
And in his case, it's under Regulation 18, when deciding whether to issue a residence card,
Yeah.
that they would have had to, on any analysis, have made an assessment as to whether or not it was in a durable relationship.
And that's the consequence of 18.4 and 5,
Yeah.
at page 1495 read together. And 18.5 is effectively the analogue to the provision at the end of 3.2 saying
Yeah.
take into account personal circumstances. I'm asked by Ms. Smythe to refer you to Article Regulation 8.8, which I will happily do. Regulation 8.8 is at page 1492 of the bundle. And it's, again, on this topic of extensive examination, where it's required under these regulations, it must include an examination of the following: the best interests of the applicant, particularly where the applicant is a child, the character and conduct of the applicant, and whether an EEA national would be deterred from exercising their free movement rights if the application is refused. I'm most grateful. So that's a further fleshing out of what individual consideration means. And then the final piece is Regulation 21, which you've heard a lot about, 1499. And let's take this slowly. An application for documentation under this part, or for an EEA family permit under Regulation 12, that's the out-of-country act.
So that's an application for a residence card under Regulation 18 must be made, yeah.
Online, submitted electronically using the relevant pages of the government website, by post or in person using the relevant application forms specified by the Secretary of State on that website. All applications must be accompanied by the evidence of proof required by this part of Regulation 12, as the case may be, and to be complete. So if you leave any box blank that can't be left blank, it's defective. An application for a residence card or derivative residence card must be submitted while the applicant is in the UK. When an applicant is submitted otherwise than in accordance with the requirements in this regulation, it is invalid and must be rejected. And the words "must be rejected" were inserted by a statutory instrument in 2019. 6. Where there are circumstances beyond the control of an applicant for documentation under this part, and as a result the applicant is unable to comply with the requirements to submit an application online or using the application form specified by the Secretary of State, the Secretary of State may accept an application submitted by post or in person which does not use the relevant application form specified by the Secretary of State. That is a very narrow, very deliberately narrow exception, and not one that on its ordinary language could apply to the circumstances of Mr. Celik. So that's the regime. Can we now proceed to look at the reasoning of Mr. Justice Lane? Back to the core bundle, tab 4. And it's the passage under the heading Discussion 1, the Withdrawal Agreement, starting at page 43 of the core bundle. And as he says, and we agree, the withdrawal agreement lies at the heart of the case. It's necessary to examine in some detail how the withdrawal agreement applies to a person such as the appellant who was or may have been in a durable relationship prior to the 31st of December. Article 126 basically says during the transition period it's the same rules, no dispute about that. Part 2 makes provisions in relation to citizens' rights, etc. Family members defined, etc. 48, he's not a family member to whom Part 8 applies. He's not a person in Article 10.1e's terms who's residing, we agree. By the same token, he's not within 10.1f, we agree. Accordingly, and here is the nub, the only way the appellant can bring himself within the scope of Part 2 is if he can fall within Article 10.2. And I think from what follows, he means 10.2 through to 10.5. Sets out 10.2, sets out Article 3.2 at 51, and the obligation of extensive examination. 52, there can be no doubt that the appellant's residence in the UK was not facilitated before 11. Well, that, with respect, is not the totality of what's required. It's enough that an application was made. It was not enough that the appellant may by that time have been in a durable relationship with the person whom he married. And then 53, and this really is the heart of the reasoning, if the appellant had applied for facilitation of entry in residence before the end of the transition period, Article 10.3 would have brought him within the scope of the article, provided that such residence was being facilitated by the respondent in accordance with the national legislation thereafter. This is not, however, the position. For an application to have been validly made, in this regard, it needed to have been made in accordance with Regulation 21 of the 2016 regulations. That required an application to be made and effectively accompanied by the applicable fee. 54. After the 30th of June, a favourable decision by the respondent by reference to pre-31st December application results in a grant of leave under the EUSS regulations rather than a grant of residence documentation under the 2016 regulations. Now, we puzzled over that quite extensively, and it echoes something that the learned judge also said in the Batul case at paragraph 68, I think, 67. What lies behind this, and we discussed this carefully with Miss Mai, so what I hope I'm about to say is an agreed position, is this. That as of the 30th of June 2021, when the grace period came to an end, the Secretary of State stopped issuing residence cards altogether. But of course, under the demands of the Appendix EU, the language of the requirements of the Appendix EU and the language of the definition of relevant documents, which I referred you or asked Mr. Hawkins to refer you to this morning, required you to present a residence card. So what happened, in substance, was the Secretary of State stopped physically issuing residence cards as of the 30th of June 2021, but started issuing pieces of paper that said if I was still issuing residence cards, I'd have given you one. And I'm going to accept that piece of paper as sufficient proof of your possession of a residence card in order to treat you as having established that for the purposes of your application under Article 18 and for the purposes of Article 18(1)(l) in particular. I hope that's a fair summary. My learned friend's nodding. That's what we think is being referred to by the learned judge here. There is no change in the law. Strictly speaking, the transitional provision is that contained in the relevant transitional regulations that simply say, and Ms. Smythe has identified the relevant provisions in para 3.3 of Schedule 3, the 2019 regulations, if you've made an application for a residence card under regulations 17 or 18 before IP completion day, then that application will be seen through and determined, including with any appeal rights. So that was the legal position. And then after 54...
Sorry, isn't paragraph 55?
I was about to say, 55.
What he says at 53 is all hypothetical. The problem is, as a matter of fact, paragraph 55.
Yes, but what he's saying is the applicant has made no such application. Exactly. What is meant by such application is plainly set by paragraph 53.
Oh, yeah, exactly.
It's a valid application.
No, with respect, it just means if the appellant had applied before the end of the transition period.
No, with respect, my lord, it doesn't mean that.
Right.
It means that they have made no such application. And the such application can only be a reference back to paragraph 53 and its indication as to the requirements of any application in order to be valid. So what he is saying is that the appellant has made no valid application, and that's that.
But is that really right? I mean, paragraph 53 has got two parts. the first part is, if he'd done something, what thing should he have done? Applied for facilitation of entry. And then for it to have been validly made in this regard, it would have need to be made in accordance with Regulation 21. And 55, it's referring to the latter part, is it? Or to the whole of it, because they're both necessary parts?
It's referring to paragraphs 53 and 54, because 53 is saying this is what you need to do for a valid application. 54 is saying a valid application after the 30th of June won't result in a residence card, but simply in the grant of leave, because you get this piece of paper. But either way, it's still concerned with a valid application. That is one complying with Regulation 21.
Because it made no such application, does it tell us why the judge regarded it as not being an application? One, because there was no piece of paper bearing the word application for facilitation of entry, or two, because there was such a paper, but it was not on the right form. I just don't think we know, do we?
Not on the right form, because otherwise what is the purpose of referring to Article 21?
I'm sorry to stand up, but one has to bear in mind that these arguments were not advanced before the judge
Oh, right.
in this form. They've been advanced by the interveners. The court has heard the way that Mr Hawkins has put his case. It's
Yeah.
quite different.
Well, with respect, if you turn to the case of Batul, which the same judge decided very shortly before this case, and it's tab 43 of the authorities manual, you see at paragraph 49, first of all, page 1181 of the authorities manual.
Tab 43.
Yeah. In order to make a valid application, the person...
Sorry, wait a minute. Which paragraph?
49.
49.
Page 1181.
Thank you.
It's the same point as to what is a valid application. And it was common ground that the appellants did not make a valid application for the EEA family permit in accordance with Regulation 21 before the end of the transition period, even though they could have done so. And it's that fact that then, when worked through the facts of the case, and it was a case where the appellants were trying to pivot from an argument that they were Article 2.2 conventional declaratory family members into an argument that they were in fact Article 3.2 extended family members, that then proved fatal at paragraphs 66 through to 71.
The reason why I have some difficulty with this reading 55 is partly what... Is it Miss Smith or Miss Smythe?
It's Smythe, my lord.
It is Smythe, I'm so sorry.
Thank you.
Miss Smythe has said is that it wasn't argued. And I look at paragraph 5 of the decision onwards, and that's dealt with the first application, and it says the appellant did not appeal against that decision. 5 is the appeal with which we are concerned arose in the following way, and then it's described. And then at 8 it says, following his marriage, the appellant made an application under the EU settlement scheme for leave to remain on the basis that he was the spouse. So when you then read 55, you've got to bear that in mind, and he's used the words very differently in 53. If the appellant had applied for facilitation of entry and residence, he would have been within the scope of 10.3, and for that to be valid, it would have to be the right form. But as he says, as we have seen, the appellant made no such application, and you can only see that by looking back at the facts,
Well, with
which is
respect,
5 to 8. Otherwise, you wouldn't see it anywhere else.
I probably can't improve on this submission. I'll try it one
Sorry,
time.
yes.
The most natural reading, I would suggest, of 55 is that it follows the discussion at 52 through to 54 about the nature of the obligation of facilitation and what it is that you need to do in order to make a valid facilitation application. It is, with respect, unnatural to read the reference to such application as a reference back to paragraph 5 of the decision.
Mr. Delamain, let's assume that you're right about that. Right? What we're, at the end of the day, having to do in this court is decide what the law is.
Absolutely.
We're not, at the end of the day, with respect to Mr. Justice Lane, engaged in a sort of linguistic exercise about what he meant. Right? We've got to get the law right. And if the fact is that the appellant did not apply before the end of the transition period, then how does Article 10.3 help?
Our case is that he did apply,
Right.
and that his application in August,
Yeah.
referring to his unmarried partner,
Even though that's been disposed of and there's been no appeal against that disposition.
and that's the point my
Yeah,
learned
I
friend.
know. We're coming back to that tomorrow. I get that.
But you're
But-
building up tomorrow. Miss Ward is going to build on your shoulders and say this was refused because Regulation 21 applied and it was an invalid application and was rejected accordingly.
It was
What
a
happens
re-
if it's refused for some other reason? If the government took parts of the treaty to heart and said, oh, we're not going to stand on ceremony here, not for us to worry about is it every box, but we don't think it fulfills something, would that be enough? Is this wholly dependent on Regulation 21, in other words?
Go back to my Lord Justice Singh's point, which is that it is useful to test things by reference to hypothetical questions. Imagine on the 30th of December, my wedding on the 28th having been cancelled. I make a last-minute, desperate application for a durable partnership under 10.3. So I've received good advice and I'm told that that's what I should do. And imagine in my hurry, I have omitted the postcode or set out my credit card details.
Yeah.
In those circumstances, the logic of the judge's position and the logic of the Secretary of State's position is that's it.
Yeah, but does your submission depend on what was actually the subject matter of the decision, or are you saying it doesn't matter what words the Secretary of State used in the decision, because, according to Mr. Justice Lane, it could never have been valid, even if they considered it, even if they'd granted it, they shouldn't have, because it was never valid.
It's the latter, my lord.
It's the latter. It could never have been a valid application.
The approach is that there could never, in these circumstances, be an application that was admissible so as to trigger the operation of the personal scope of the withdrawal agreement unless you complied with every I and every T in the national procedure. And that is a mistake of law. And once that mistake of law is apprehended, and that there is an EU law test of what it is to make an application, has to be bounded by EU law at the end of the day, because EU law has to control unreasonable national procedural barriers. The whole edifice crumbles down.
Right. So because there could never be an application that was capable of triggering Article 10 unless it complied with Regulation 21.
It means there's a whole...
Hold on, sorry, I've got to write it down as well, and I'm slower. Unless complied with Regulation 21. I'm wondering what that means. That means that any document sent in had to be seen as an application capable of generating a need for an individualised decision, and any failure to do so on any ground whatsoever means that application is still in existence.
Yes.
Yeah. Okay, let me write that down as well then. Hold on.
Yes, it does.
Yeah. Okay.
Unless there's a more
Oh,
proportion.
hold on. So any document that seeks the ability to stay, I'll put it like that, seeks the ability to stay in the UK,
I am
but
driven...
does not comply with 21, must be treated as an application for a residence card and or US leave, and will remain undetermined, whatever the language of the decision saying it's not going to be granted. That's got to be the position, hasn't it?
Well, it has to be, because the rule in question is uncompromising. The rule says, in terms, it is invalid. And what it doesn't do is supply some more flexible metric by reference to which to assess whether or not the deficiency is so bad that it should be treated as invalid. And you've got a choice between black or white. And with respect, there is nothing particularly radical or new about these submissions. This is just a withdrawal agreement specific application of notions of EU law that go back to 1977, Raver, and the principles of effective protection the attacks on time limits or procedural rules that have characterised EU law.
I'm not suggesting anything at all at the moment, I'm just trying to write them down.
So
Could never be an application that was capable of Tribunal unless it complied with Regulation 12. Therefore, any document that seeks the ability to stay in the UK but doesn't comply with Regulation 21 must be treated as an application for residence/EU settlement and will remain undetermined because it would have had to be refused on the basis of invalid.
now, what we obviously accept is that there is a threshold question as to whether or not any particular mistaken application is in substance an application for treatment as an extended family. So you can't just simply point to any document and say, well, in my subjective view, that was an application for extended family membership. There's got to be some reasonable indicium that that is what it is. But there's no doubt, there's no dispute that any sensible reading of what Mr. Celik was attempting in this case was to say, here's my relationship with my EEA national partner, it's durable, here's the evidence of our cohabitation, bill sharing, etc. Please treat me as being her unmarried partner, a durable partner, etc. And that is enough of an indicium. There will be other cases in which the Secretary of State is entitled to say, quite fairly, well, there was no trace in this application of that being your case, I'm sorry, goodbye. So, can I then very briefly, because I must finish today, I understand, deal with the points my learned friend Miss Smythe makes in her skeleton argument in response, supplementary skeleton argument in response to the issue. And I'll pick up at the second point she makes in her skeleton. It's paragraph 7. And her submission is at tab 14 of the core bundle, page 181 and following. The second point she makes at paragraph 6 is that the 3-2 rights sui generis are based on national legislation. The simple answer to that is we agree, but that doesn't answer the fact that that sui generis right is plainly bounded by EU law, as the cases of Rahman and Banger show, and that it is not some untrammelled discretion to be exercised out of EU law control. The third point is, she says that Article 10.3 imposes a simple cut-off point by requiring an application to have been made under the existing domestic EFM rules by 11 p.m. To which we say, no, EU law requires an application to have been made, but national rules of manner and form or validity cannot impair the substance of that right. The point that they effectively say, because your application hasn't complied with this particular procedural requirement, we're going to treat you as having made no application at all. And that is not undermining the clear express terms of Article 10.2 and 10.3 as paragraph 8 charges. It is in fact giving effect to the content of Article 10.5, the provisions of the CRD upon which 10.3 and 10.5 build, namely Article 3.2, Article 15, 31 and 28, and the case law of the CJEU. The fourth proposition is that if the general principles of EU law did apply, the appeal would still fall to be dismissed. Why? Because there was a facility for an EFM application to have been made and there was a right of appeal. But that is a fundamentally arid assertion in circumstances where the argument doesn't grapple with the essence of the point we make, which is the cliff edge created by Regulation 21, seen against all the pointers in Article 18 of the treaty as to what a fair and compliant constitutive process more generally would look like. In particular, the clear pointer in Article 18.10 that you're meant to operate a collaborative process in which you don't fail people for having used the wrong form. And so this argument with respect, and you'll see it when it's unpacked in the further provisions of Ms. Smythe-Skeleton, doesn't actually engage with the essence of our complaints of disproportionality. And then finally, she says, we have conflated two discrete applications and rights, namely the EFM process and the EU SS process. And I hope, having heard me at probably tedious length, you will no longer think that, because we have not at any stage conflated the two processes. At most, our argument is that the controlling content of EU principles governing the first stage process are meaningfully informed by the controlling content of the second constitutive process, and that therefore you can rely upon or use the latter to divine the acceptable boundaries of procedural rules of the kind at issue in this case. I've taken a lot longer than I was given permission for. You've been extremely patient. Unless there's anything else I can assist with.
Any questions? No, thank you very much indeed. So start again tomorrow at 10:30.
All right.